Hi, folks. David Graff from Graff talking about master and sub-association foreclosures. Not exactly the most sexy topic alive, but something that comes up from time to time and causes management boards and our office to scratch our heads sometimes. So the purpose of today is to give a little bit of insight on why this would ever happen, what's the statutory authority on how these happen, what are some of the pitfalls and things that we need to look at when it does happen. And the context obviously is that someone in the community is not paying their assessments to either one or both of the associations. Usually there's not more than two associations, but theoretically there's no limit to the number of master and sub-association hierarchies that could exist. But today our conversation is premised under the idea that there are just two. And for ease of use, I will assume for all purposes that we, meaning us for purpose of today's conversation, is representing the sub-association, and there's a separate master association that is out there and that is perhaps owed money. So I think that'll make it a little easier. And one of the things that we see is that, especially when the master and sub-associations work together, there may be overlap in terms of greenbelt maintenance or architectural oversight. They may be chummy for good reason, because they get along and they don't fight for the benefit of their owners. And that's a great thing. And what we have to remember is that the law doesn't necessarily care about that. Even though we're talking about the same house or condo unit, each association is going to be a legally separate and distinct entity with its own rights and obligations under completely separate declarations. And so we have to be careful of that. Go back to that almost stilted formality and thinking of these things as two totally separate entities, because they are. And when we get into a good working relationship with the master, we can get ourselves in trouble if we forget how separately they are legally. And I'll get back to that at the end. I just wanted to start out by reminding us that, for purposes of today, a master and sub doesn't exist unless they each have separate declarations and have separate corporations. Now, we can have a faux master and sub relationship set up in a single governing document, and that doesn't necessarily create a master and a sub. So if you have, different types of products, planned community, condos, patio homes interspersed, you can arrange for that in one declaration under one HOA. That does not create the master and sub association relationship. It has to be two separate entities, two separate sets of declarations. Because, again, even though it is one unit that we are talking about, it's the same unit, it's completely separate authority, corporations, collection policies, procedures, boards, voting ownership, all of those things are separate. And we have to be very careful not to blur the lines between the two when we're trying to handle a case involving one unit owner and saying, what difference does it make? That's the master association. We're all in this together. Well, we are, but we want to make sure that we have the formalities handled appropriately. It's important to point out that there's a difference between what type of a foreclosure an association here in Colorado can pursue versus a bank, a lender. A public trustee foreclosure, and I think we're either one of the only or the only public trustee state in America. The public trustee is a government office in each of the counties in Colorado. And what they do is, when you borrow money, let's say the bank has you sign a deed of trust. And what that says essentially is that you, the borrowing owner, authorize the public trustee to hold this deed of trust. And in the event that you don't pay the lender, if the lender goes to the public trustee and says the right magic words, which is you didn't pay, then the public trustee is authorized to foreclose the home and sell it at auction on a very expedited process. That process is not available to associations. We have to do what's called a judicial foreclosure. Judicial meaning court-based. What does court-based often mean? Expensive and slow. And that's exactly what it means for a judicial foreclosure compared to a public trustee foreclosure. It's much more expensive and much slower than a public trustee foreclosure. So we just have to know that because one of the things we talk about with clients is, hey, there's going to be a foreclosure. Should we do a foreclosure? And the thing that we're trying to look at, when we don't have a crystal ball and we don't know usually is the bank going to do their own foreclosure? Because if they do, they will do so quickly, much more quickly than we will. They will end up wiping out the association's interest in most cases, except for the super lien. And essentially they'll do the dirty work for the association at no cost to it other than wiping out its lien. But if the association starts a judicial foreclosure and spends all that money, and then partway through that, the bank starts its own public trustee foreclosure, it's going to finish first and it's going to wipe us out, all things being equal. And there's always nuances in terms of priority of the bank's lien that doesn't match the normal protocol. But generally, they're going to wipe us out and we're going to get our 6 months and they're going to be on their merry way and we will have wasted money in that foreclosure. We don't want to waste money on behalf of our clients. CRCP is Colorado Rule of Civil Procedure. 105 is the rule that authorizes the the judicial foreclosure. And what we're supposed to do is name all of the parties that have an interest in the property. And if we don't name all the parties that have an interest in the property, then we have what's called an omitted party, and that can create some unwinding of the foreclosure that we'd rather not indulge in. So we would typically name all of the interested people in the property so that they had the ability to participate in the foreclosure, and we can either reach agreements as to their priority and any payout, or we can wipe out their interests if they're junior to the associations. And one of the questions we get a lot is from a sub-association board, well, we were named in a foreclosure brought by the master association, but the homeowner isn't delinquent to us, the sub-association. The answer is that's right. It's not always the case. In fact, it's usually the opposite, because usually when you stop paying your master assessments, you stop paying your sub-association assessments, but you don't have to. And we've had this, come up multiple times over the last many years where the sub-association says, so why are we named in this case? They don't owe us anything. The answer is because the master was being thorough in how they prosecuted the foreclosure and named us because we had an interest in the property. And so what do you do? Well, you usually contact the master association's attorneys and we work out some agreement. Either we're not going to get paid, or if the arrearage starts after the foreclosure, here's how the payout will go if there is to be one. It's important to remember that many associations, especially at the infancy of a collection, the person's 20 days, 30 days, 60 days delinquent, the association will not have a recorded lien against the property. Now, most encumbrances on real estate are memorialized by a lien that's recorded in the clerk and recorder's office in the county where the property is located. Not always the case in association operations. And I'm not aware of any other scenario where this weirdness exists. And the weirdness is that Kiowa, Colorado Common Interest Ownership Act, Section 316 says that an association has an automatic statutory lien on the property as soon as the owner becomes delinquent without recording a lien. Weird. Great. Because that is a gap filler. If the association hasn't recorded a lien, it means we still have an interest in the property, and the interest that the association holds relates back to the filing of the declaration, which is great. And that's how we get the super lien. Just remember, this doesn't exist, to my knowledge, anywhere else in the law outside of HOA operations. Normally, you have to record your lien against the property, and if you don't have a recorded interest in the property, you don't have a lien against it. Not an association world. What happens when the master forecloses and the sub-association isn't owed anything? Usually, as I said, we'll contact the lender for the master and work something out if we can. Now, here's where it gets interesting, or maybe not interesting, depending on what seat you're sitting in as a board member, a manager, or someone else. Priority in foreclosures is all about who's above or below somebody else. And it's like a very narrow ladder where people are standing on different rungs. And in lien priority, there's not really the concept of people standing on the same rung where they have equal priority. Either you're above or you're below. However, Kiowa messes that up a little. What they say is that unless the documents provide otherwise, master and a sub that have liens on the same property have an equal priority lien. Oh, okay, that makes sense, right? It sounds intuitively sensible, but it doesn't mesh with the greater body of foreclosure law, which is heavily reliant, in fact, dependent upon lien priority. Who's above, who's below. We know what to deal with who's above. We know how to deal with who's below. How do we deal with somebody standing on the same rung of that priority ladder as us? Very difficult. Not the end of the world, not something that we haven't been able to figure out. It's just another abnormality that the statute creates in what is otherwise a pretty well settled foreclosure proceeding. Because when we talk about foreclosures, junior liens are wiped out in the foreclosure and senior liens survive. If they're senior to us, they survive our foreclosure. If they're junior to us, they're wiped out. Well, what happens with an equal priority lien? I don't know. It's not senior and it's not junior. That's why I say it's interesting. And those are the things that we argue about. And normally, what we do is, like I said, we talk to the attorney for the other party, the other association, and if they're not completely unreasonable people, we will resolve the issue without any major argument and without any major expense. There are other states have cases that resolve this issue, which I don't think necessarily help Colorado's situation, but we're waiting someday, God forbid, that we have to really argue about what this equal priority lien means to the extent that one of the parties is alleged to have been wiped out. And the other interesting thing is when we go to the sale, we have to provide a bid, and we typically add on the, well, we determine fair market value and essentially subtract the senior liens from that. And it's not clear how an equal priority lien factors into that, right? Because it's not senior. So we have to be careful. And again, the converse is, does a junior priority lien get extinguished? Well, yes, it does. Is an equal priority lien a junior lien? No, it's not. So is that extinguished? No. So how do we get, so again, I don't want to spend a bunch of your brain power worrying about these esoteric issues. It's the statute says what it says, and it's said what it has said for many, many years, a couple decades now. It's not something to lose sleep over. We just need practical solutions, right? What do we do? Well, sometimes we would look to see whether one of the parties could collect the assessment on behalf of the other in the same case. Why? Well, because it doesn't duplicate the cost to either client. It certainly doesn't duplicate the cost to the owner. And while some boards may not care about the cost to the owner, if an owner's delinquency is doubled, tripled, or quadrupled because we're filing multiple foreclosures, even though we have the right to do that, they're never going to dig out of that hole, or it may be a very deep hole for them to dig out of. And what we would love, if we can help it, is for all of our homeowners, to pay their assessments and to live in dignity and never have to involve us at all. That would be a great world, right? So to the extent we can avoid doubling or tripling or quadrupling the cost to the owner and getting them back on the non-delinquency list, that would be a fantastic thing. However, sometimes in association world operations, no good deed goes unpunished. And we can't necessarily collect on behalf of another party without express language, either in the governing documents or by agreement. Sometimes we'll see governing documents that say the master can collect for the sub, or the sub can collect assessments for the master. And if that's the case, we're a lot closer to being able to do it in one case with one letter and one lawsuit, and not double or triple or quadruple the cost to the clients or to the association or to the homeowner. But that's pretty rare that we see that good language that provides that authority to collect on behalf of another legally separate and distinct entity. So be careful, it's not very common. The other thing that we sometimes do is that we might do a joint representation of the master and the sub for that limited purpose, such that we can bring one case collecting the debt on behalf of each. Sounds very simple, but what it does is it creates conflicts of interest, because our loyalties to one client, the sub, might be adverse to our loyalties to the master, especially if they're not owed the same amount. And so we have to get a conflict letter signed by each of the boards after disclosure to them of the potential conflict. And then we want to talk about in that agreement a payout schedule, because if the master association's assessments are $100 a month, for example, and the sub associations are $500 a month, for example, when we collect a certain amount of money, how do we pay that between the two parties that are each owed money? Is it relative to what's owed? those are the types of issues that create conflicts of interest. So we have to be very careful in how we would undertake that joint representation. I think the worst case scenario, although perhaps the legally cleanest, is that the master and the sub bring their own foreclosures, each represented by a different law firm, but it's expensive, damages the homeowner significantly because of the increased costs, and sometimes creates a situation where the lawyers for the master or the sub are arguing about, well, whose lien is equal? Well, do we get $1 or do we get $2 when there's a recovery? And so that sometimes, like I said, having that adversarial system, creating an opportunity to be adversarial when we don't need to be, hurts all the parties. So we just have to be careful in how we think about this, not going so far overboard that we're trying to save the homeowner who's in arrears from themselves, but we certainly, would want to be mindful of the costs and the dynamics between the two associations. So I hope this helps. Be careful, and if you have any questions, we'll be here. Thanks again.